Verdict in the tattoo punch murder trial in Wisconsin. The jury deliberated about 3 hours or so. The verdict came back about just under 2 hours ago. Because of course you've hit the pause button throughout the day. We want to take you now back to court where that verdict is being read.
Ms. Wolf, are you the jury foreperson?
Yes, sir.
Has the jury reached a verdict?
Yes, we have.
I'd ask that you hand that verdict to the bailiff, please. The court is going to ask the clerk to read the verdict.
We, the jury, find the defendant guilty of felony murder, aggravated battery with the intent to cause bodily harm as set forth in count 1 of the information.
Is there any request to poll the jury?
No, Your Honor.
Are there any motions?
State moves for motion, moves for judgment on the verdict, Your Honor.
Thank you.
Judge, I'm going to rethink that. Would ask that you poll the jury.
It has to be polled?
Yes, please.
Madam Clerk, would you please poll the jury?
Nicole Cummings.
All right, so the audio was down in the courtroom because as they polled the jurors, they're actually saying their name. We're looking here at the defendant, looking very much different than he did back then. All right, looks like they're back. The audio's up. Let's go back in the court.
From the defense.
For judgment notwithstanding the verdict, please.
Thank you. Court will deny the defense motion. I'll grant the state's motion. The court will revoke bail and conditions at this time. Remand the defendant to the custody of the sheriff. We'll schedule this for sentencing. We'll pick that day, time and date in a moment. Ladies and gentlemen, this concludes your work as the jury on this case. I want to thank you for your effort. This is obviously a very difficult fact situation, and I know that the parties accept and believe that your effort was genuine and that your focus was true. I want to thank you for that. You're going to be retiring back to the jury room to collect your things. Tom will have some information for you, and I will speak to the parties briefly, and then I will be available if you have any questions about your experience. So I will stop at the jury room where you're assigned if anyone wishes to have an opportunity to ask any questions. All rise.
Really, at the end of the day, it's like the worst possible scenario for a fight in a bar, an argument in a bar. One punch ends the life of one man and really ends the life of a second man who now at 65 could go to jail for almost 30 years. So let me bring in our guest, trial attorney, law professor Joe Richardson. Joe, your reaction to the verdict?
I'd love to tell you I was surprised, but I wasn't. You know, just a couple things stick out for me. First of all, visually, when you've got video, you know, it's hard to talk against it. And aesthetics are very important. And this guy was twice this other guy's size. He was twice his size. And he can say that he didn't mean to hurt him, etc. But he also had opportunities. I mean, this guy tried to leave. Our eventual deceased here was trying to leave. I'm not saying he was completely and totally faultless in everything. People were drunk and folks got hot. But at the end of the day, it looks like this defendant did not have to resort to basically following this guy out to the parking lot or chasing him when he hears back from him and that kind of thing. He had an opportunity to make some choices here where he could have kept this thing from escalating, and he chose not to do that. And then, again, when you assault the jury's intelligence, if something contrary to what they're actually saying, video is a thing. You're going to start from the video. If the video's clear and you're saying something different than the video, you might have a problem, and that's what we have.
Joe, I was surprised he didn't take the stand to tell his story. I don't know what his background is, if there's anything in his background that could be a problem. He did give some inconsistent statements to police, but I thought it was necessary, and I didn't think he had that much to lose by taking the stand and talking about what happened that day. Clearly, the jury could see a lot of what happened based on the video, but what was going on in his mind, I think, might have been important and maybe helpful to him. Were you surprised he decided not to testify?
On this particular case, yes, I was. It seemed like that would be the only way. The person that couldn't testify against him was the deceased. Dead men tell no tales. And for where he was and for what the video actually says, it's one thing if there is no video and we're going back and talking about what may have happened, that might have been the difference if there's no video. But there's actual video. He's got things to explain, and he needed to take a chance with doing that. There was some risk inherent in it, for sure. But as we see, he wouldn't have been any worse off for having done it. So I thought, and we've talked about this before, I thought if there was a case, or the kind of case where somebody really ought to get on the stand and go for his, that this would be that kind of case. So it was a bit surprising that he didn't do it.
Yeah, I thought the same thing. I thought this was one where there wasn't a whole lot to lose for him, and I thought certainly he could help himself if he testified properly. He seemed like a regular guy up until this point. Felony murder in this case. There are a lot of felony murders. You've been around the system where, felony murder can be a rough one. You certainly understand the policy behind it, and in a lot of cases, you're glad it's there. Someone goes and does something awful, someone dies as a result, and they should be responsible for it. This one feels a little odd to me. I'm wondering where you think sentencing might go. He's facing up to 30 years. I don't know if there's mitigators. Again, he acted pretty much like a buffoon that day. But at the end of the day, it was an argument in a bar. There was one punch thrown. It wasn't even a brawl. It was one punch thrown. There can be some argument that he maybe thought that the throwing of the stool was an attack on him and he just responded. I mean, there are ways to mitigate it, I think, but your thoughts on a possible sentence?
Anyone that has been in a situation like this or witnessed it would probably be able to tell you that they didn't expect somebody to die. And so because of what happened, it was certainly a tragic consequence. He was a bonehead, for sure. He's criminally liable, for sure. But I would be surprised if under these particular circumstances, particularly given his age, that he would have the book thrown at him. He hit him once, not justifying that he hit him once, but most of us that have hit someone once as an adult didn't expect them to die as a result. We might have wanted to hurt them. We might have intended bodily harm, because in his case, he didn't like the guy because he had on tattoos and he was telling them he was going to hell. So he needed to hit him as well. So, an agnostic or an atheist may throw the book at him. But I don't know that in this particular case, maybe he gets 5 to 10 years. Maybe he gets something that's a little bit more, amenable to perhaps him maybe getting out of jail before his life is over.
Yeah, I mean, again, this is one of those weird ones because on one hand, I can make that argument. On the other side, this guy was a father, a husband, a brother, a son, and he's dead. And is he dead as a result of the actions of this guy, according to this jury? I don't know, maybe 30 years is appropriate. I don't know. All right.